Hi, everyone. Harry here to talk about Donald Trump's continuing and somewhat desperate efforts to resist paying the mammoth $500 million or so, what's a few 30, 50 million between friends, bond in the A.G. James case. So remember, this is the case in which he has been ordered to disgorge some 450. It grows every day because of interest. And he had previously said, oh, that is too much and it's going to be impossible to get. Basically, we're going to be able to reverse on appeal anyway and the like. And the AG came back and said he hasn't even shown his efforts and he's saying already it's too much. All right. So today, Donald Trump filed a 30-page memorandum with like 4,000 pages of exhibits saying, all right, I will now show you that it's too much. And it's a portrait of a man in a company, if it's to be believed, that has tried everywhere to get a humongous bond and has been unsuccessful. So the motion is for a stay of this huge bond, which is provided for by law. The very first argument that the parties are tussling over is, how mandatory is it? It appears to be that there is some authority, not surprisingly, in where we are now, by the way, in the Appellate Division, the mid-level of the three levels of courts in New York, the trial level called the Supreme Court, the very top level they call the Court of Appeals. Don't ask me why. And then the middle level is the Appellate Division. And in that division, the first argument is how much authority that the Appellate Division itself has to reform or set aside a bond. So the first part of the brief is devoted to an argument that you can do it and it's pretty routine to do it and it's no big deal to do it. And that's to counter the New York AG's argument that, wow, it theoretically exists. It has to be a very strong and rare case. It seems as if to square these, we haven't heard from the AG, but it's pretty rare to have, judgments and bonds needing to be posted of over $500 million. So we're talking about a very small sample set that perhaps courts of appeals reduce at, with some frequency there. You can't tell from the face of the papers. But that's the first thing, is they try to argue plenty of authority. Then they go to what's going to be the headline, which is raising this amount of money they call a practical impossibility. So if you take that literally, that means Trump basically is tapped out. Not to the extent of, he needs to take the street with a tin cup, but the argument is that it's an empirical argument about how big companies operate. First, he says no private bond companies will think about this. It has to be publicly traded, really big money bond companies. And he says they require collateral of like 120%. So if you default, a huge amount of money you have to raise. It's sort of like getting them to put it up, and so you don't have to do it, but then you're on the hook for 120% of it. And the big rub seems to be that they require it in certain forms, basically securities, pieces of paper you can trade for money, not big real estate holdings. And so in order to get those pieces, or he's got real estate is the argument, and it's probably true. But in order to cash that into securities to get a bond, he's got to sell them. And that, his argument goes, you can see it, is irreparable injury. Just to get this bond, to have to basically liquidate all my holdings one of the requirements of a stay is you show injury that can't be repaired were you to win on appeal. And he's saying, I would be left without my real estate empire. Then he goes basically to the merits. He's got to get a stay generally. It's, different according to the causes of action and the jurisdictions, but basically you got to show irreparable injury and a likelihood of prevailing on the merits. So he makes a few arguments. First, he says that the trial court got a statute of limitations argument wrong, and that the right argument would require the injury to the people of New York to have been completed by a certain date, and that some 75% of the injury falls under that rule and should be set aside. They argue that they can expect it to be set aside at the Court of Appeals level. And then the old, they try in 2 or 3 different ways the argument they've been making all along, which is nobody got hurt here. The banks still got paid. And they present that in part as a causation argument, that the offense didn't cause the harm, and therefore the amount of the stay of the bond they have to post is miscalculated. Of course, that's just they've been beating that argument until it's a dead horse and past it. The statute says when you cheat, that the people who were cheated were the people of New York. That's the Attorney General brings it in their names. They wound up paying back the banks, but they should have done it at a much higher rate because it was riskier loans, because they lied about the underlying holdings. Therefore, this, it's a non sequitur or just an irrelevant to say, oh, but nobody got hurt. Now, that piled onto that is pages and thousands, literally, of affidavits and interviews and transcripts. But the big one is by a financial representative who's been trying to negotiate the bond, who basically goes through all these steps that they've taken and trying to show diligence and how they've been rebuffed. So to answer the claim that they haven't been trying. So it sets up quite an interesting ruling for the Appellate Division. It may be, the AG might or might not, normally come in after reply, but you often can if you choose to. So there may be challenge on the facts about how much they've done. But if it's the case that he's now really at the point of, having to go grinding deep into bone, that would be the big real estate holdings, and having to do that in order to collateralize or make securities of his real estate in order to get this gargantuan bond. Now we are talking about, it's already been some pretty big financial blows landed, including the need to have posted the $90 million or so in the Stormy Daniels case. But this would have a feel of, if not quite ruin, deep damage and irreversibly so. So in that sense, and sort of supports one aspect of his argument to his, real estate empire. So this is almost existential, and the Appellate Division holds his fate in their hands. Of course, at the end of the day, if they affirm, all this will have to be paid anyway. And the ruling of the wording of the statute really suggests this is just something you have to do in order to get the appeal. Though it's true there is, this sort of safety valve, and the argument really will be, I think, over this first part of it, how much play in the joints is there for the Appellate Division to knock this down, et cetera. Very hard to predict how it goes. I can tell you the feel of it is if it were, 2 anonymous litigants, not the AG of New York and not Donald Trump. It's the sort of thing an Appellate Division would do, would want to favor the hearing of the claim, and would reduce with some persuasion of the irreversible injury. But, in this case, I think even intuitions, and, these are my intuitions about New York law, which I couldn't call myself an expert on, have to go out the window because they're all driven by the court's perceptions of the litigants involved, and especially Trump. So this is a dramatic now setup for the Appellate Division, which, if it goes ahead and says, sorry, Mr. Trump, a bond's a bond, an appeal's an appeal, post it now or don't bring the appeal. We're talking, unless they're lying in their affidavits, something they've been known to do, but that lawyers don't typically do. And the consequences are large, but unless they're lying, we're talking about a, real serious damage to Trump's real estate empire. So that's something to follow closely, and it won't take that long to play out because this is all a so-called emergency motion to stay. We're at the reply stage. We'll hear from the Appellate Division soon, and I think their ruling will, in practical effect, even though a party can try to take a extraordinary appeal to the highest level, the Court of Appeals, I think what the Appellate Division says will stick. So stay tuned for that. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.